And I believe, Mr. Harpootlian, you're going to handle the first issue.
Yes, Your Honor.
We're ready to proceed.
Please the court, Your Honor.
Yes, sir. Good morning.
Good morning, and as I understand your instructions, I get 5 minutes without being interrupted?
That's right.
Wow. Well, first of all, I want to thank the court for, I know what has been a very diligent effort to wade through this record, a 6-week trial, and then a post-trial hearing that went a few days with additional, 2 hearings, I think, with additional record. So this is not a simple matter. But before I get to that, I want to just remark on this. As I came into this courtroom this morning, I'm reminded that half a century ago, I sat right about there.
51 years ago, I took an oath to uphold the Constitution. Today, I understand what that truly means. This case is about the Sixth Amendment, the right to a fair trial, because without it, no freedom matters. It's about a jury free from outside influence, justice without corruption, and defending one man's right to fair trial, no matter how unpopular that may be.
As Chief Justice Woodrow Lewis had us stand and hold our hands up to be sworn in as new members of the bar, all of us could fit in this room. That's how long ago that was. But one of the things that impressed me that day was the oath, and part of that oath was that we swore to uphold the Constitution. And as I stand here today, I'm honored to be arguing about how to interpret that Constitution, the Sixth Amendment specifically. And in my opinion, I would suggest the Sixth Amendment may be the most important amendment, because the First Amendment, which gives you the right to speak without government interference, or the Second Amendment, which gives you the right to carry a weapon or have a weapon without government interference, mean nothing without the right to a fair trial and a fair jury. So this matter we're discussing this morning, a fair trial, a jury not poisoned by outside influences, I would submit to you is 51 years ago, as I stood there, I did not realize what I was swearing to do, but I do today. And that is to defend Alec Murdaugh's right to a fair trial. And I've got to admit, in the 51 years since then, I've never seen a factual pattern like this, where the clerk of court, sets out to influence the verdict, to get a guilty verdict for financial gain. Now, I do want to go to the record fairly quickly and summarize it so that there's no misunderstandings. Rhonda McElveen, who's the Barnwell Clerk of Court, was asked by Becky Hill, the Carlton Clerk of Court, to assist her during the Murdaugh trial. She testified under oath that she was told by Ms. Hill that she, being Ms. Hill, might write a book because she needed a lake house. A guilty verdict would sell more books. That was said before December of 22. We didn't pick a jury until January of 23. The best way to sell books was a guilty verdict. A guilty verdict would be better for the sale of books. So she explained she had a financial incentive for a guilty verdict. She also made comments to her like, "Don't be fooled by the evidence presented by Mr. Murdaugh's lawyer. Watch him closely. Just before he testifies, look at his actions, look at his movements."
Watch him closely. Don't be fooled. Don't let them confuse you. These weren't the words of jurors. They were spoken by the clerk of court. Multiple jurors testified under oath that Becky will comment on Alec Murdaugh before he even testified, while the case was still ongoing.
Identical to the statements that I'm going to read you in just a moment by the jurors as they were questioned. Juror P, on the day Mr. Murdaugh was taking the stand, Becky Hill made a comment, "Watch his body language." Juror X, prior to Mr. Murdaugh's testimony, Juror X heard Becky Hill say words to the effect of, "Looks like the defendant's going to testify." This is an important day. This is an epic day. It's rare for a defendant to testify. Juror Z, watch his actions, watch him closely. In addition to that, Juror Z said in an affidavit and affirmed in court that Ms. Hill told her not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which she understood to mean Mr. Murdaugh would lie when he testified, and that Ms. Hill instructed the jury to watch him, Murdaugh, closely immediately before he testified, including look at his actions, look at his movements, which Juror Z understood to mean he was guilty. Alternate Juror 741. Before the defense put up their case, Ms. Hill told the jurors the defense is about to do their side. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Hill told Juror 741 Murdaugh was going to testify before he testified. That's what the jurors said under oath. That's what the Clerk of Court of Barnwell County said under oath. Judge Toll, from the bench, said at the conclusion of the hearing, asked the question, did Clerk of Court Hill make comments to any juror which expressed her opinion as to what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find the Clerk of Court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed it as early as November 22, long before the trial began. She denies that this is so, but I find that she stated to the Clerk of Court, Rhonda McElveen, and others her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified. She made some of those comments before he testified to at least one and maybe more jurors. The Clerk of Court allowed public attention of the moment to overcome her duty.
Can we consider the egg juror's affidavit?
I'd like you to.
Well, in the record, of course, you mentioned during the hearing, she's across the street. Judge Toll said, no, she's not going to testify. She let the alternate juror testify for impeachment of Ms. Hill. That's correct. What her stated reason for was during the hearing. What was the rationale for her not allowing the egg juror to testify?
I don't know. Because, as you point out, if Juror 741 was to impeach Becky Hill's credibility, now, of course, she was not a deliberating juror.
Well, neither was the alternate.
Correct.
Who did testify.
Correct.
So my question is this, and I'm sure Mr. Waters will cover this.
Why wasn't the egg juror allowed to testify? Her affidavit was in the record, yet the court never fully explained why she couldn't speak. Meanwhile, other jurors testified under oath about the clerk's statements, warnings to watch him closely, to not be fooled, to ignore the defense. These statements went directly to her credibility and to the integrity of the trial.
If the egg juror's testimony was just as theoretically impeaching as Juror 70 or the alternate juror's testimony, 741, why wasn't the egg juror allowed to testify?
And I'm not sure that she stated a coherent reason other than she wasn't going to. Remember now.
But she said her affidavit is in the record, so we know what she said, Ms. Hill said,
right.
And we now know what Ms. Hill said she didn't say.
Yes.
So I take that to mean that it was considered. The egg juror's affidavit was considered by the court, and we can consider it.
In our defense, when you look at the record, remember, we were starting off with no one was going to examine anyone under Judge Toll's initial order. And then it was a moving target. Then it was going to be some that were going to be examined. We weren't going to be allowed to examine. Then we were allowed to examine. So it was an evolving process. If she, in fact, considered the egg lady's affidavit, she did not cite it in her order, just as she did not cite Juror Z or 741's statements about do not be fooled, comments about how the attorneys are going to try to deceive.
The state argues in its brief that Judge Toll, in making specific findings as to certain things jurors did say, was an implicit rejection of the other statements the jurors said Ms. Hill made. What's your response to that?
Well, I would say that's wholly unsupported by the record. I mean, a judge in an order is going to say what they considered and they should say what they didn't consider and why. This implicitly, I mean, the statements by 741, by Juror Z, and by the egg lady all had bearing on Clerk Hill's credibility and what happened. It's critical. And let me say this also. Even if you didn't have what they said, if a judge, as the jury came in on the day Mr. Murdaugh was going to testify, said, it's an important day, it's an epic day, you better watch how he testifies, and doesn't say that about any other witness, except some sort of charge at the end of the case, or maybe before, but specifically points that out.
Mr. Harpootlian, let me ask you this. Judge Toll placed the burden on your client to prove prejudice in this case. Does Green establish, in a case with external influence on a jury, a different standard and burden of proof than Rimmer and the Fourth Circuit jurisprudence?
No, it does not. It's consistent with Rimmer. All Green says is, we're not going to go through this burden shifting or any of this until we determine whether the statement was inconsequential. I say inconsequential or consequential. And if it is inconsequential, we're not going to go through this analysis. That's all it said. And I'd point out in Green, the process used by Judge Toll of calling all the witnesses up and asking them if it had any influence. Judge Hill, in a footnote in the Court of Appeals Green decision, points out that 606B, he says it's not raised in this case, but should we be asking jurors anything about verdicts? And that's another complicating factor with the process that Judge Toll used. So
the clerk of court made improper comments to the jury. Judge Toll described them as limited in subject and not overt as to opinion. But the record tells a different story. The comments were frequent, pervasive, and prejudicial. No jury instruction can erase that. This was not harmless. It was a clear violation of the Sixth Amendment.
That's an interesting point, because Rule 606B says that you can't consider the effect of something on jurors, because otherwise you're invading the thought processes of the jury. But how could the state rebut the presumption without doing that?
Well, I mean, I think very simply, all the other cases that you look at, if you look at like Parker versus Gladen, where a deputy says he's an evil fellow and he's guilty,
right?
They say this, you can't rebut that. That's not rebuttable, and so he gets a new trial.
But in Parker versus Gladen, they talked about the prejudice.
Well, it's the prejudice is apparent if you use the standard some of these cases use, which is the hypothetical juror. Would it objectively influence the hypothetical juror? I mean, I think that's what the state has to do, is say these comments would not affect the hypothetical juror.
But in your brief, you also say that the presumption ought to be irrebuttable. Are you standing by that here today? Or are you wanting us to follow Rimmer and Parker and say it is rebuttable, but you have to use the objective standard on an average juror in considering the effect?
Well, it is. I would concede that it should be rebuttable, but in a situation like Parker versus Gladen, I don't know how you rebut it. I mean, it may just be it's rebuttable, but there may not be any way to rebut it. So
in some circumstances, the conduct can be so reprehensible and egregious, it becomes a de facto structural error.
Well, I read your opinion, Rivera, Court of Appeals, on structural error, where the judge refused to let the defendant testify in a death penalty case. And I've digested, or as my wife would say, digested, not digested, I'm sorry, that case and the structural error analysis. And I must say that Mr. Griffin and Mr. Barber and I have had a significant discussion on whether that would be structural error as opposed to not letting a defendant testify in a death penalty case. It could be, but I don't think we need to go there for this opinion, for this case. I think the clerk of court tells everybody that'll listen, I need a guilty verdict. She tells everybody, so I can make money. She tells everybody, so I can buy a lake house. And then she proceeds to talk to jurors, not about inconsequential things, but focus on how to view the defendant's testimony, and to juror Z and to juror 741 into the egg lady, don't believe him, don't believe his lawyers. I mean, that's, I submit, more than enough to meet the Parker versus Gladen standard, or the Cameron standard, or I think it's Bennett, the case we looked at, I just looked at yesterday. All of those are cases in which there's no question what was said wasn't inconsequential, wasn't neutral. It was an effect to influence.
Is it a finding of fact?
The clerk of court made improper comments to the jury. Judge Toll described them as limited in subject and not overt as to opinion. But the record tells a different story. The comments were frequent, pervasive, and prejudicial. No jury instruction can erase that. This was not harmless. It was a clear violation of the Sixth Amendment.
A conclusion of law by Judge Toll, where she wrote on page 31 of the record, this court further finds that the improper comments made by Clerk Hill were limited in subject and not overt as to opinion. I know you say that language was put in there by the state in its proposed order. I don't want to talk about that because she signed the order. But is her finding that the statements were limited in subject and not overt as to opinion a conclusion of fact or law?
That's a conclusion of fact, which gives rise to a conclusion of law. But that statement is wholly unsupported by the record. And I would submit an abuse of discretion.
And how about her finding that those comments were cured by Judge Newman's overall jury instruction that the verdict was to be based on the evidence presented and the law as he gave it and not on anything else?
Well, then you would never have, as long as the judge gave the appropriate charge at the end of the case, you'd never have a case of jury tampering. You could have somebody bribing a juror, and according to her reasoning, they I took the money, but I'm not going to do what I said I'd do. I mean, I don't believe for a minute that is an appropriate analysis of the law. Whether I believe it or not is really irrelevant.
So the allocation of the burden of proof is not dispositive in your judgment. Even if it was erroneously assigned to you, you believe you met that burden of establishing prejudice because of the nature and frequency, the pervasiveness of these comments by the clerk.
If you use the analysis in both the Court of Appeals decision of Green and then the Supreme Court decision in Green, if you look at the analysis, that's exactly what it is. There's not going to be any burden shifting or anything if it's innocuous, but if it is something other than that, then the burden does shift to the state, and we've met our burden. There's no second. She had a two-prong test. Second prong was, did it affect the verdict? Well, I mean, if somebody that can't work for Rule 606B for one, but more importantly, you're asking jurors to unpack for you what influenced their verdict. How did they get there, which you can't do under 606B, and people can't do, period. I mean, if somebody had walked in there with a gun and threatened everybody and then left, and the jurors were polled a year later saying, no, I thought the evidence was overwhelming. It didn't matter whether somebody walked in with a gun or not. And overwhelming evidence is not the standard. This Sixth Amendment, I was going to go somewhere historical. I'm not going to do that. But, yeah, I am.
The Sixth Amendment guarantees a fair and impartial jury, regardless of the crime, the accused, or public opinion. As Chief Justice Marshall noted in Aaron Burr's trial, a juror must be as indifferent as he stands unsworn. In this case, that guarantee was violated. Extrajudicial influence reached the jury.
The Sixth Amendment was based on as you know, English common law. In the trial of Aaron Burr in 1807 for treason, this is not for killing Hamilton, this is for trying to sell part of the United States to Mexico. He was a piece of work. Chief Justice Marshall quoted from Lord Coke, who said, "A juror must be as indifferent as he stands unsworn. His verdict must be based upon the evidence developed at the trial. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, and the station in life which he occupies." You can't say it any clearer, and that's what the Sixth Amendment guarantees. And that didn't happen in this case.
We understand that everyone, regardless of the heinousness of the offense, the character of the accused, or the apparent guilt of the accused, in no manner diminishes the right to a fair trial. In your effort to set up that this is a man for all seasons moment, we understand the gravity of the situation and the entitlement of every individual to a fair and impartial trial.
Your Honor, I never doubted that for a moment. I think I was saying that more from me than you, because it's such a great quote, and again, came up during Aaron Burr's trial, who's such a terrible person, but even he was entitled to a fair jury. You know, we quote in our brief, and I want to expand on it just a little bit. If you look at United States versus Elbaz, which is a Fourth Circuit case written by our own Jay Richardson, he details what Remmer requires, to trigger the presumption, the defendant must introduce competent evidence of extrajudicial juror contacts that are more than innocuous intervention. And I submit we've done that in this case. But the presumption's rebuttable. The government defeats the presumption by establishing there exists no reasonable possibility that the jury's verdict was influenced by an improper communication, which was not done in this case. And you should exclude, at least one, I would point out, Juror Z said it did. I mean, if we're going to go that way, now it may have been ambivalent. Judge Toll says, I said in the record, it can be both pressure from the jurors and what Clerk Hill said. But I don't think we need to go there because 606B and almost all the cases about external influence don't allow you to ask the jurors questions about how they got where they got.
Part of Parker versus Gladen was the Sixth Amendment was violated because the bailiff there who said this person's...
A fair trial isn't about convenience. It isn't about the weight of the evidence or the severity of the crime. The Constitution guarantees 12 impartial jurors, without exception. Yet here, the clerk of court injected bias, pressure, and influence. No amount of evidence can undo that Sixth Amendment violation. Justice is not optional. Alec Murdaugh was entitled to it.
Guilty, this wicked fellow, whatever, became a witness in the case. Is that what you're saying Clerk Hill became in this case?
Well, not necessarily. What I'm saying, Parker versus Gladen, they only needed 10 or 12 to get a conviction. And the Oregon Supreme Court said, well, we had 10 that weren't influenced by whatever the bailiff said. The Supreme Court said very clearly, doesn't matter, you're entitled to 12 impartial jurors. Also, that was the case in which the United States Supreme Court adopted, through the 14th Amendment, the Sixth Amendment to the states. So that's the reason I like Parker, because it's got so many different levels that are very helpful in this case.
And in Parker, did it took 10 to convict in Oregon, right?
Yes, sir.
How about Judge Toll's finding that even if the state had the burden, she found any possible presumption of prejudice was overcome by the facts and the court's findings? She did conditionally rule that if I'm wrong about the burden, then the state has overcome that burden. Well, the presumption, excuse me.
Two things. One, she doesn't detail what that overwhelming evidence is. And you're going to hear from Mr. Griffin in just a moment as to how underwhelming that evidence is, number one. Number two, that can't, the level of, if the level of evidence dictates whether or not you get a fair jury, then again, we go back to what Judge Marshall said, no matter how heinous, no matter how overwhelming the evidence, you're still entitled to a fair trial. I mean, if only the people that may be innocent get a fair trial, then our Constitution isn't working. I don't care. I would submit this court shouldn't care. No one should care when there's a Sixth Amendment violation like Becky Hill committed in this case. And let me say this. I know my time's up. We spent months getting ready for this trial, weeks, 6 weeks trying this trial, more months finding jurors to talk to and find out if the court could talk to her, could talk to them. We had more hearings, more briefing. Nobody wants to do this again less than we do. But that's not the issue. It's not how much trouble it's going to be. It's what is Alec Murdaugh guaranteed to under the Sixth Amendment.
Thank you, sir.
Thank you, sir.